Hi, my name is Muhammad Haikal and I'm the first presenter. I want to talk about the financial statement. A financial statement is a comprehensive report that contains all the financial and accounting information about a company. It's a key tool for understanding a company's financial positions and performance. By reviewing the financial statements, investors can gain valuable insight into the company's overall financial health and make informed investment decisions. The first one of the financial statement is profit and loss. The profit and loss statement is a financial statement that represents a company's revenues, costs and expenses incurred during a specific period. It provides a summary of a company's profitability and identifies areas for improvement. The second one is the balance sheet. The balance sheet is a comprehensive report that presents a company's financial positions on a specific date. The third one is audit report. An audit report is a written letter from the auditor containing their opinion on whether a company financial statement comply with the generally accepted accounting principle (GAAP) and are free from material misstatement. The independent and external audit report is typically published with the company annual report. The audit report can help ensure that a company financial statement provide a true and fair representation of its financial positions and performance. By reviewing the audit report, investors can have greater confidence in the accuracy of the financial information reported by the company. Now, I would like to discuss with you the requirement for appointing an auditor. In public company, there are several regulatory requirements that must be met before an auditor can be appointed. These requirements include the first one, regulatory oversight. All public companies are subject to regulation and oversight by governmental agencies. This regulatory oversight ensures the reliability of a company financial statement and help to protect the interests of both investors and the general public. The second one is audit committee. Public companies are required to establish an audit committee that is responsible for overseeing the audit process and ensuring the independence and objectivity of the auditor. The committee is typically made up of non-executive directors with expertise in finance and auditing. The third one is rotation requirement. Public companies are required to rotate their auditors on a regular basis to reduce the risk of auditors becoming too close to the company management. The fourth one is a shareholder approval. In some countries, public companies are required to obtain shareholder approval before appointing an auditor. This ensures that the interests of the shareholder are taken into consideration during the appointment process. And the last one is enhanced independence standard. Public companies are required to adhere to enhanced independence standard when appointing an auditor. This includes ensuring that the auditor is independent and impartial and does not have any conflict of interest. As for private companies, the requirement for appointing an auditor are slightly different. The first one is the less regulatory scrutiny. Private companies are not subject to the same level of regulatory scrutiny as public companies. Therefore, they have a greater flexibility in selecting the auditor and are not required to comply with the same level of regulations. The second one is flexibility in selection. Private companies are not required to appoint an auditor from a pre-approved list or to obtain shareholder approval. This allows them to have more flexibility in selecting their auditor and to choose the auditor that is best suited to their needs. And the third one is no shareholder approval. Private companies are not required to obtain shareholder approval before appointing an auditor. The decisions to private companies have greater flexibility in selecting the auditor and are not required to comply with the same level of regulations. And the fourth one is less stringent rotation rules. Likewise, private companies are not subject to the same stringent rotation requirement as public companies. And the last one is limited public disclosure. Private companies are typically not required to publicly disclose their audit report. So, to sum up, while both public and private companies must appoint an auditor to provide an independent assessment of their financial statement, their requirement and regulations surrounding the appointment process differ between the two types of companies. Public companies are subject to greater regulatory oversight and are required to adhere to more stringent rules and regulations, while private companies have greater flexibility in selecting their auditor.
Thank you for the first presenter. My name is Nistora Medan Ananam Yasmanam. As a second presenter, now we continue the presentation. According to Section 27, Section 2 of Companies Act 2016, notwithstanding Section 1, the registrar shall have the power to exempt any private company from the requirements stated in that subsection according to the condition as determined by the registrar. For example, Company A wants to appoint an auditor to audit their financial year. They have to apply to appoint an auditor to the registrar. Unfortunately, the registrar not allowed the Company A to appoint an auditor. Now, I will move on to the meaning of an audit and objective of an audit. In general rule, auditing is the financial statement for public company is compulsory and optional for private company. Audit is a systematic examination of financial information, records, or operation to provide an independent and objective assessment. The first objective of an audit is accuracy and reliability. In these cases, financial statements should be verified so that financial statements are accurate and reliable, reflecting the true financial position of an organization. Next is verification of transaction. The auditor should confirm the validity of transactions recorded in financial statement to avoid fraud in the account. Other than that, the objective of an audit is detection and prevention of fraud. The auditor should identify and address fraudulent activities or errors within financial records. Besides, next point of an audit is enhancing credibility. An auditing provides assurance to stakeholders such as investors and creditors regarding the credibility of financial information. The last objective of an audit is continuous improvement of the financial statement. An audit offers recommendation for improvement in financial statement and operational process based on audit findings. Next, I will move on to the procedures for payment, right, and responsibilities of an auditor. There are several functions of an auditor. An auditor is an independent professional authorized to inspect, review, examine, and verify the accuracy of business record to ensure true and fair account of the past financial performance and current financial position. Hence, the function of the auditor is to ensure that the financial information as to the companies concerned prepared by the directors precisely reflect the company's position. There are two essential functions of an auditor. First is to report to the members of a company on various matters relating to the preparation of the company's financial statements. The second one is to report to the registrar of company (ROC) on any breach of the Companies Act 2016 which were not appropriately dealt with. Next, I will move on to the comparison between internal auditor and external auditor. For internal auditor divided into audit committee and internal auditor. Meanwhile, for external auditor is divided to the appointed by the company's shareholders. Internal auditor consists of internal mechanism set up by the company. Meanwhile, external auditor has extensive duties and obligation toward the shareholders, company, and third parties. The next one, internal auditor is the main objective of the internal auditor is to detect and prevent error and fraud. Meanwhile, external auditor is to show fair and true view of according records. The last one for internal auditor. Internal audit is submitted to the management. Meanwhile, in external audit, the report is submitted to the shareholders. Now I will move on to the appointment of an auditor. According to Section 264 of Companies Act 2016, of the Companies Act 2016, subsection 1, a person shall not, subsection A, knowingly consent to be appointed as an auditor for any company. Subsection B, knowingly act as an auditor for any company. Subsection C, prepare for or on behalf of a company any report required by this act to be prepared by any approved company auditor. If subsection Roman 1, he is not an approved company auditor. Subsection Roman 2, he is indebted to the company or to a corporation that is deemed to be related to that company by virtue of Section 7 in an amount exceeding 20 to 25,000 ringgit. Subsection Roman 3, he is subsection A or his spouse is an officer of the company. Subsection B, a partner, employer and employee of an officer of the company. Subsection C, a partner or employee of an officer of the company. Subsection D, a shareholder of his spouse is a shareholder of a corporation whose employee is an officer of the company. Subsection Roman 4, he is responsible for all of if he is the partner, employer or employee of a person responsible for the keeping of the register of members or the register of member of the register of debenture holders of the company. Subsection Roman 5, he is undischarged bankrupt within or outside Malaysia except with leave of the court. Subsection Roman 6, he has been convicted of any offence involving fraud or dishonesty punishable with imprisonment for 3 months or more.
Hi, my name is Kennedy Osirislanang Anna Michelle. I'm the third presenter. Now I will talk about the continuous of Section 264 of Company Act 2016. The continuous of this section is subsection 2 for the purpose of subparagraph subsection 1, subsection 3, subsection Roman 3. A person shall be deemed to be an officer of a company if he is an officer of a corporation that is deemed to be related to the company by virtue of section 7 if he has been an officer or promoter of the company or such a corporation at any time within the preceding period of 12 months unless the minister direct otherwise. Subsection 3, for the purpose of this section, a person shall not deem to be an officer by any reason only of having been appointed as an auditor or of a corporation. Subsection 4, a firm of auditors shall not knowingly consent to be appointed and shall not knowingly act as an auditor for any company and shall not prepare for or on behalf of a company any report required by this act to be prepared by an approved company auditor unless subsection A, all the partners of the firm resident in Malaysia are approved company auditors, and here the firm is not registered as a firm under any law for the time being in force. A return showing the full names and address of all the partners of the firm has been lodged with the registrar. Subsection B, no partner of the firm is disqualified under subsection 1 from acting as an auditor of the company. Next is subsection 5. A company shall not appoint a person or a firm as an auditor unless prior to the appointment. Subsection A, that person has consent in writing to act as the auditor. Subsection B, in the case of a firm, at least one partner of the firm has consented in writing. Next is subsection 6. The appointment of a firm in the name of the firm as auditor of a company shall take effect as an appointment as auditor of the company of the person who are partners of that firm at the time of the appointment. We will move on to subsection 7. The appointment of a firm in the name of the limited liability partnership or foreign limited liability partnership as auditor of a company shall take effect as an appointment as auditor of the company as if subsection A, the partner of the limited liability partnership, whether the partners at the time the limited liability partnership was appointed as auditor or later. Subsection B, employees of the limited liability partnership who are approved company auditor in that limited liability partnership, whether employed at the time the limited liability partnership was appointed as auditor or later, are appointed as auditor of the company. Subsection 8, any person who is or any firm which is appointed as an auditor contravenes subsection 1 or subsection 4 respectively commits an offence and shall, on convicting, be liable to fine not exceeding 100,000 ringgit. Now we will move on to requirement for public and private company auditor. A person that appointed by the company or firm to execute an audit should be approved by the Minister of Finance. Next, an approval and renewal of approval is valid for 2 years unless revoked by the Minister and other requirement. For example, he or she need to meet the criteria relating to professional expertise and experience capable of performing the duties of an auditor and has good character. He or she should be not related to the company and independent. The next one is not owed more than 25,000 ringgit from the company or any related company. He or she also given the written consent of the appointment to be an auditor. And the last one is registered as a chartered accountant by the Malaysian Institute of Accounts. Next, we will move on to the person responsible for the appointment of an auditor. The first one is in private company. The person responsible for the appointment of an auditor is typically the board of directors of the company's management teams. In some cases, the company governing documents such as the company constitution or charter may also specify the process for appointing an auditor. The choice of an auditor is an important decision for a private company, as the auditor will provide an independent assessment of the company's financial statement and the other reporting requirements. Therefore, it is important to carefully consider the qualifications and experience of prospective auditors and to ensure that the chosen auditor has the necessary expertise and independence to perform the functions effectively. Next, we will move on to the requirement. Next, we will move to the person responsible for the appointment of an auditor in public company. The person responsible for the appointment of an auditor is typically the board of directors of the company. It is the same as the private company, but it will add in management team and it's subject to approve by the shareholder. The appointment of an auditor is an important decision for a public companies, as the auditor will provide an independent assessment of the company's financial statement and other reporting requirements to the company, shareholders and other stakeholders. Therefore, it is important to carefully consider the qualifications and experience of the prospective auditors and to ensure that the chosen auditor has the necessary expertise and independence to perform the functions effectively. The last one is the appointments of an auditor typically occurs annually at the company's annual general meeting, and the shareholders then vote on whether to reappoint the existing auditor or to appoint a new one. That's all from me. Thank you.
Hi, my name is Alex Anaguan as the fourth presenter. Now, I'm going to present the methods of appointment of an auditor for private and public company. Let's delve into 5 points that I have highlighted of the methods of appointment of an auditor for a private company under Section 267 of the Companies Act 2016. The first point, first auditor. Upon the incorporation of a private company, the initial responsibility for appointing the first auditor lies with the directors. For instance, the appointment by the BOD or Board of Directors of a newly incorporated companies should be done at least 30 days before the end of period for the submissions of their first financial statements to the registrar under Section 267 Subsection 3. This ensures that the companies promptly establishes a framework for financial accountability and reporting. The next point is subsequent auditors. Following the initial appointment, the subsequent appointment or reappointment of auditors becomes a recurring process linked to the company's annual general meeting or AGM. At each annual general meeting, the directors and shareholders engage in the decision-making process regarding the auditing function. An auditor may be appointed to fill a casual vacancy, which is usually done by the Board of Directors under Section 267, Subsection B. The third point is shareholder ratifications. Shareholders, as the ultimate owners of the company, are granted a significant role in the appointment of auditors. During the AGM, they have the authority to ratify the appointment of the current auditor. This involves a review of the auditor's performance and a collective decisions on whether to continue the existing auditor or opt for a change. However, if there is no auditor appointed, the outgoing auditor is deemed to hold office. In this context, deemed auditor is not the actual auditor. But under Section 270, Subsection 1 of Companies Act 2016, an auditor of a private company shall not be deemed to be reappointed under Section 269, Subsection 3, if the company has received a notice under these sections from members representing at least 5% term of the total voting rights of all members who would be entitled to vote on a resolution that the auditor should not be reappointed. The fourth point is shareholder appointment. In the event that directors fail to fulfill their duty appointing an auditor, the Companies Act 2016 empowers the shareholders to take charge of this critical task. Through a resolution passed at the general meeting, shareholders can appoint an auditor, ensuring that the essential audit function is not overlooked or neglected. The last point for these private companies is licensed auditor requirement. A crucial stipulation is that the appointed auditor, whether for the first time or subsequently, must be a licensed auditor as per the provisions outlined in the Accountants Act 1967. This requirement emphasizes the need for qualified and competent professionals to carry out the auditing function, contributing the integrity and reliability of financial reporting. Next is the appointment of auditor for public companies. An auditor should be appointed in every financial year of the company as stated under Section 271, Subsection 1. If the company fails to appoint an auditor at the annual general meeting, Section 271, Subsection 4 stated that the members of the company shall appoint an auditor by ordinary resolution at the AGM. The same goes to if the board fails to appoint an auditor under Subsection 2. In addition, an auditor is appointed by the registrar upon written application of any members if the company fails to appoint an auditor. An auditor should be appointed prior to the first AGM. Section 271, Section 2, Subsection A stated that an auditor should be appointed at any time before the first annual general meeting of the company. Next, an auditor is appointed to fill a casual vacancy to occupy the position of an auditor in the office, as stated at Section 271, Section 2, Subsection B. That session pertains to the removal of auditors before the expiration of their term. Specifically, this section outlines the circumstances under which a company may remove its auditor. In the context, it typically allows removal when a special resolution is passed by the company. A special resolution usually requires the approval of specific majority of shareholders, often not less than 75%. So in simple terms, that session provides a legal provision for a company to remove its auditor through a special resolution passed by the shareholders before the completion of the auditor's term. Briefly explaining, Section 273, an auditor ceases to hold office at the conclusion of the AGM following his or her appointment, unless he or she is appointed by the BOD or Board of Directors. Besides, an auditor does not take office until the previous auditor has ceased to hold office unless he is the first auditor of the company.
Hi, my name is Nell Carson and I'm the last presenter. Now let's move to the next part, qualification of an auditor. Approval and validity of approval by the Minister of Finance has been stated in Section 263, Subsection 1 to Subsection 4 of the Companies Act 2016. Section 263. company auditors to be approved by minister charged with responsibility for finance. Subsection 1. Any person may apply to the minister charged with responsibility for finance to be approved as a company auditor for the purposes of this Act. Subsection 2. The minister may, if he is satisfied that the applicant is of good character and competent to perform the duties of an auditor under this Act, upon payment of the prescribed fee, approve the applicant as a company auditor. This subsection means that the applicant has no criminal record and has the ability to perform the duties of an auditor, may be approved by the minister if he is satisfied with the applicant. Subsection 3. Any approval granted by the minister under subsection 2 may be made subject to such limitation or condition as he thinks fit and may be revoked at any time by him by the service of a notice of revocation on the approved person. Subsection 4. Every approval under this section, including a renewal of approval of a company auditor, shall be enforced for a period of 2 years after the date of issue unless sooner revoked by the minister, which means that an approval and renewal of approval only valid for 2 years, or at a shorter period if revoked earlier by the minister. And the last part is requirement of an auditor. Based on section 264 subsection 1 of the Companies Act 2016, section 264 company auditors, subsection 1, a person shall not, subsection A, knowingly consent to be appointed as an auditor for any company. Subsection B, knowingly act as an auditor for any company. And subsection C, prepare for or on behalf of a company any report required by this Act to be prepared by an approved company auditor if subsection Roman 1, he is not approved company auditor. Subsection Roman 2, he is in debt to the company or to a corporation that is deemed to be related to the company by virtue of section 7 in an amount exceeding 25,000 ringgit, which means that he shall not owe the company or a corporation related to the company in excess of 25,000 ringgit. Subsection Roman 3, he is, subsection capital A, or his spouse is an officer of the company. Subsection capital B, a partner, employer or employee of an officer of the company. Subsection capital C, a partner or employee of an officer of the company. Or subsection capital D, a shareholder or his spouse is a shareholder of a corporation whose employee is an officer of the company. Subsection Roman 4, he is responsible for, or if he is the partner, employer or employee of a person responsible for the keeping of the register of member or the register of debenture holder of the company. This subsection Roman 3 and subsection Roman 4 basically means that he, the auditor, shall not have any connection or relationship with the company. Subsection Roman 5, he is an undischarged bankrupt within or outside Malaysia except with leave of court. Or subsection Roman 6, he has been convicted of any offense involving fraud or dishonesty punishable with imprisonment for 3 months or more. That's it. Thank you.